So, I'm going to say, the court says Kwesi was never a member of parliament ab initio. He never existed in parliament. His name should be expunged. The EC says, now let's go for a by-election. And in this by-election, the NDC says, we are putting up Kwesi because he's qualified. No problems about that. He has his renunciation certificates. No problems about that. The people say, because there's a criminal trial, you ought to be, a little careful. What do you say to that, those who say that?
Well, so first of all, let me thank my senior and comrade, Dr. Tonedu. Took a lot of inspiration from him when he was in active politics, and still look up to him for leadership and direction. I've read the Theories of Justice. If you want to understand the ideal of justice, read Amrita Sen. He's written a locus classicus on justice. And it's always important, whether it's puritanical or social justice, to ensure that justice is done in any situation. I mean, the other side of justice is accountability. Okay, and so when a pronouncement of a court is made and it just goes, then what is justice? What is justice?
I think we don't need to relitigate that.
No.
You shared your view. He also shares his view.
I'm not really taking
He also shares his view.
Yes. But it is important
human nature that we cannot all agree. And you can accommodate his views without, compromising yours.
I'm accommodating his views, but I'm just saying that Amrita Singh idea of justice will be very important for anybody who wants or who is pursuing justice to read.
Okay.
Now, so the facts of, like lawyers normally say, the facts of the Judge Kwesi's case is not in doubt. And the brief facts are that somewhere between September 2020 and October 2020, he put in an application to renounce his Canadian citizenship in Canada. Normally, that application takes 3 months to complete. The COVID pandemic, according to Judge Kwesi, deprived the Canadian authorities of working full-time. The nominations for the 2020 elections were opened between 7th and 9th of October. 7th and 9th of October. On the 20th of October, he got his certificate of renunciation. 11 days after nominations had closed, he got his certificate of renunciation. But because he put in the application to renounce his Canadian citizenship, that application was acknowledged by the Canadian authorities, and he was informed that they were processing his application for renunciation. He submitted same to the Electoral Commission.
When someone challenged that he could not.
He could not. When he was challenged that he could not, he submitted same to the Electoral Commission. And the Electoral Commission, upon examination of the documents, felt that he had evinced an intention to renounce his citizenship. And that in their view, was enough proof that he had renounced his citizenship.
But the application, he put the application in 2019.
19?
Yes.
In 2019.
I think you said 2020.
No,
2019.
2019. I said between 2020, September and October.
Okay.
But in 2019, the application was put in. So that's long before So what I felt the Supreme Court did was to hold the letter, and consistent with the decision in the Senator, where they said that the eligibility of a person takes effect upon the opening of nomination. And so since on the 7th, between 7th and 9th, he did not have the certificate of renunciation, never mind that he didn't have, he showed that he evinced an intention to renounce. For us, he didn't have. And so, and so he was disqualified. Now, when you look at this...
That one, though, is it, as some people suggest, is it not too much of a strict interpretation of the process? Some people say that's the height of constitutionality, because you are dealing with a court that is dealing with interpretation method that we call MOPA, right? Modern purposive approach. So that you are benevolent to the facts rather than being strict, you know.
Exactly. And when you read philosophy, benevolence, compassion should animate human thoughts. Okay, your conscience itself must be founded on your compassion, love, and understanding of the human nature. Okay, and so that also should animate the courts. I'm of the view that if they had used MOPA, they wouldn't have come to that conclusion. But they were bound by previous decision. And the Supreme Court, the Constitution says...
They are not bound by previous decision.
No, as much as possible. That's what the Constitution says. That as much as possible. They can depart. But in this case, they didn't depart. Okay.
Well, there's also the other argument, though, which clearly shows that we haven't seen their decision yet, but which clearly shows that they don't agree with that view, which Professor Assin and the rest continue to espouse with authorities. They don't just say as matter of opinion, with authorities, judicial decisions, to the effect that, first of all, in Canada, renunciation doesn't actually require the certificate. Once you have done it, you are done orally, you are done it, you are gone. But more substantively, allegiance is not the same.
Say that it's a pleasure coming back, hearing my voice again on Newsfile after more than 24 years.
Wow.
The first and last time was in 1999.
Right.
Yeah. But
okay.
Something.
Yes.
I wanted to make a very brief comment on the Supreme Court judgment on the Domilovo case. I thought you called me for that too.
Please proceed.
Yes, very briefly. Obviously, the Supreme Court has come to judgment when time has rendered the matter consequentially functus, so far as Domilovo's right is concerned, and in fact, in several aspects of the matter relating to public interest. But I must say, with regard to what my friend Inu Sapuseni said regarding the impeachment of the president, Inusa, I think it's about time that we call a halt to some of our style of politicking. I'll urge you to read William Shakespeare, Merchant of Venice, where we had a distinction between puritanical concept of justice and pragmatic concept of justice. And I think this should be good for the future democracy of our country and inter-party politics. Another comment regarding Mr. Martin Pebu Esquire's comment towards the Constitution, the framing of the Constitution. It was not done to appease President Rawlings. Kwame Nkrumah never had any role in both the technical propositions nor the deliberations of the Consultative Assembly, of which I was a member, and I was also a member of the powers of government that considered the provisions concerning the presidency. Indeed, if it was to appease President Rawlings, we would have allowed the term of the presidency to be 5 years. But we hotly debated it, and it was limited to 4 years. Now, to the matter regarding the risk Christians face with the criminal prosecution.
The risk, that is, if any at all.
If any at all. What I want to observe is that criminal prosecution must be proven, or criminality must be proven on
beyond all reasonable doubt.
Beyond all reasonable doubt. That is the first one. Secondly, the prosecution must prove mens rea, that he had criminal intention to commit the offense that he did. Thirdly, there is the factor that he had reasonable belief that what he was doing was right. Reasonable belief can vitiate guilt in criminal prosecution. And finally, there is the element of reasonable steps that he took to prevent his commitment of the offense. These are four principles of criminal justice that must be taken into account. That's all I have to say.
Okay. Dr. Tony Edu, thank you very much.
You're welcome.
Right. So those were rather deep and, if you like, very sober, reflections on some of the, issues that we have brought to and we are discussing. So, on witness of saying, the court says Assin was never a member of parliament ab initio. He never existed in parliament. His name should be expunged. The EC says, now let's go for a by-election. And in this by-election, the NDC says, we are putting up Assin because he's qualified. No problems about that. He has his renunciation certificate. No problems about that. The people say, because there's a criminal trial, you ought to be, a little careful. What do you say to that? Those who say that?
Well, so first of all, let me thank my senior and comrade, Dr. Tony Edu. Took a lot of inspiration from him when he was in active politics, and still look up to him for leadership and direction. I've read the Theories of Justice. If you want to understand the ideal of justice, read Assin. He's written a locus classicus on justice. And it's always important, whether it's puritanical or social justice, to ensure that justice is done in any situation. I mean, the other side of justice is accountability. Okay, and so when a pronouncement of a court is made and it just goes, then what is justice? What is justice?
I think we don't need to relitigate that.
No.
You shared your view. He also shares his view.
I'm not really taking
He also shares his view.
Yes. But it is important
human
to read.
nature that we cannot all agree. And you can accommodate his views without, compromising yours.
I'm accommodating his views, but I'm just saying that Assin idea of justice will be very important for anybody who wants or who is pursuing justice to read.
Okay.
Now, so the facts of, like lawyers normally say, the facts of the Judge Assin's case is not in doubt. And the brief facts are that somewhere between September 2020 and October 2020, he put in an application to renounce his Canadian citizenship in Canada. Normally, that application takes 3 months to complete. The COVID pandemic, according to Judge Assin, deprived the Canadian authorities of working full-time. The nominations for the 2020 elections were opened between 7th and 9th of October. 7th and 9th of October. On the 20th of October, he got his certificate of renunciation. 11 days after nominations had closed, he got his certificate of renunciation. But because he put in the application to renounce his Canadian citizenship, that application was acknowledged by the Canadian authorities, and he was informed that they were processing his application for renunciation. He submitted same to the Electoral Commission.
When someone challenged that he could not.
He could not. When he was challenged that he could not, he submitted same to the Electoral Commission. And the Electoral Commission, upon examination of the documents, felt that he had evinced an intention to renounce his citizenship. And that in their view, was enough proof that he had renounced his citizenship.
The application, he put the application in 2019.
19?
Yes.
In 2019.
I think you said 2020.
No,
2019.
2019. I said
Right.
between 2020, September and October.
Okay.
But in 2019, the application was put in. So
That's
long
right.
before So what I felt the Supreme Court did was to hold the letter and consistent with the decision in the Senator, where they said that the eligibility of a person takes effect upon the opening of nomination. And so since on the 7th, between 7th and 9th, he did not have the certificate of renunciation, never mind that he didn't have, he showed that he evinced an intention to renounce. For us, he didn't have. And so he was disqualified. Now, when you look at this...
That one, though, is it, as some people suggest, is it not too much of a strict interpretation of the process? Some people say that's the height of constitutionality, because you are dealing with a court that is dealing with interpretation method that we call MOPA, right? Modern purposive approach. So that you are benevolent to the facts rather than being strict,
Exactly. And when you read philosophy, benevolence, compassion should animate human thoughts. Okay, your conscience itself must be founded on your compassion, love, and understanding of the human nature. Okay, and so that also should animate the courts. I'm of the view that if they had used MOPA, they wouldn't have come to that conclusion. But they were bound by previous decision. And the Supreme Court, the Constitution says...
They are not bound by previous decision.
No, as much as possible. That's what the Constitution says. That as much as possible. They can depart. But in this case, they didn't depart. Okay.
Well, there's also the other argument, though, which clearly shows that we haven't seen their decision yet, but which clearly shows that they don't agree with that view, which Professor Assin and the rest continue to espouse with authorities. They don't just say as matter of opinion, with authorities, judicial decisions, to the effect that, first of all, in Canada, renunciation doesn't actually require the certificate. Once you have done it, you are done orally, you are done it, you are gone. But more substantively, allegiance is not the same as citizenship. So to construe, allegiance to another country, to construe citizenship to be allegiance to be citizenship to another country is wrong. That's an argument on the other side. So stay on.
But I will also advise you again and encourage you to go and read Hans Magentor. He is the chief proponent on sovereignty and why countries... he wrote his thesis at the time that we had feudal systems of government. And so a person needed to owe allegiance to a king or a queen, because that person, that king or queen, signified the head of state, and you couldn't serve two masters. So if you were found to owe allegiance to two kings, then you were a traitor. And so that notion of owing allegiance is to a king or a queen who was the head of state.
Yeah. But the argument is actually there that once he has done it, and it is known that he has done it, just the certificate he hasn't received.
You don't say he hasn't done it. Renunciation is irreversible.
Okay.
Immediately you renounce, you put in an application to renounce. So
why do you, if there is that risk, take this risk?
There's no risk. First, so again, we are lawyers here, and we are privileged to be sitting with the former attorney.
But we are not speaking to lawyers.
No, so we are lawyers, so we understand.
All right.
So we understand that a person is assessed based on the qualification in the Constitution. Is he a certified lunatic? Is he a bankrupt? Has he been convicted of a crime of felony?
No.
Or dishonesty? Has he been sentenced to death?
He would not have been qualified in the first place.
Good. And so if you assess that person on the basis of that, tell me, on what grounds can you say that person should not contest? It can only be on moral grounds. So yes, the risk is there. I mean, if you find an attorney general who is determined to prosecute, the risk is always there. And I agree entirely with senior comrade Dr. Tony Edu. They have to prove mens rea. I mean, they have to look at the circumstances of the case. The case will have to be defended in court, okay? And you can only trust that the courts will do what is proper and just in the circumstances. But it's a risk, a calculated risk that the NDC is taking. And I don't think that the NDC has any legal basis to say that Judge questions should not run. Morally too, it would be wrong.
But politically, this is being played and will be played very effectively by the MPP in the constituency. They're already there, and we have seen bulldozers and other things that have started fixing roads that were not
the Institute of Engineers say that they've issued a statement saying that in their view, the roads that were constructed in Kumau will not last 1 year. Have you read it?
No, I haven't seen that.
Yeah, they said so.
So roads that are constructed during by-elections don't last. Oh,
they don't last.
No, so the question about the political side
of it. The people will not be swayed by.
The question about the political side of it. Question won with how many votes? Margin?
Difference of about 1,000.
About 2,000 or so.
It's a swing. It's a swing.
Actually, the presidential and another one.
Yes, it's a swing.
Yes. So a party in power, they have the money, they have everything. They will marshal it to the constituency.
Hey, they have the money,
and all they need is about 2,000 votes. You don't think they can make it?
Well, then you have a candidate who the people think that he has been hard done by government.
That's the essence of presenting him.
Yes,
sympathy.
He has been hard done by government. That this is somebody, sympathy, like you said, who in 2019 evinced an intention to contest, followed the processes of the law, put in his application. He's been held vicariously responsible for the Canadian authorities' inability to issue him with a certificate of renunciation long before the nominations were opened. And so, we think that he is the best candidate. We think that we have a duty to right a wrong, and we are putting him there, and we are going to campaign for him to emerge as the parliamentary candidate or the member of parliament for the Assin North constituency.
Okay.
Never mind the risk. Never mind the risk. Let them do their worst. Who will present him?
All right. So, Kwenka, I've seen the effective campaign machinery. Your youth group, all of them.
They've moved camp.
They say they are taking over the town and the villages there, and they are talking about works that have gone on over there. They are propagating it, and we have seen, the footages that are being shown us, the roads that are being cleared, and
some were done way before this time.
We always hear about that. Even we were told that this was already going on, but somehow the roads will not last. Only the by-election that gets the work done. So here is. I think actually he had in excess of 3,000 votes or so.
Yeah.
So how are you going to undo that?
Well, if you look at the history of that constituency, and I have looked at it carefully, the MPP has won it 4 times in the past. And so if you compare our victory in that constituency to the NDC, MPP is ahead. And the margins are always reasonable, apart from 96 that we lost by a heavy margin of about, we had 36% in 96. The rest of them, MPP clocked more than 50% in all the victories that we chalked. And the last election, as I indicated, we lost in the parliamentary, but in the presidential, His Excellency the President, Nana Addo Dankwa Akufo-Addo, won. So what it tells you, therefore, is that the majority of the people are MPP, if we go by the results. And so if you get a parliamentary candidate who is appealing to the people to take the MPP votes in the totality of it, then he wins. That's the point. Again, now I'm going to talk about the issue of what actually happened to him, unfortunate as it is, as I'll say. You see, if you look at, I have contested as a member of parliament. My senior has done it several times. There's a form you fill. And when you are filling that form, even you have to, at the end of it, you have to go before a magistrate or a judge to endorse for you and etc. It is on that form that you make the declarations, whether you are a dual citizen or not. You see, as a people, when we move over time and we realize that we've entangled our necks with certain practices and procedures that are not of any help, we must do some changes as we move forward as a people. That has been the standard form we fill all the time. Now, the form, there's a particular question. They will ask you whether you owe allegiance to any other country. That means that, for example, if you are a dual citizen, and of course, this issue of allegiance, as you have indicated, I've spoken to Professor Zhang on several occasions while in office and out of office. We've discussed it. It's a very debatable issue because if you even look at the ordinary dictionary definition of allegiance, it includes the act of swearing to commitment to become a citizen of a particular country. It includes that. So you cannot run away from it unless there's a pronouncement by the court that allegiance does not equate to citizenship, which pronouncement we don't have anyway. So once the form, the declaration is very clear, you state whether you owe allegiance. And at the time that the question was actually filing with the Electoral Commission, strictly speaking, and as we all know, and we agree, I know on the table here there's no debate about that, he did not have the certificate of renunciation at the time he filled the form.
But the EC cleared him because he had proof that he had filed the process for renunciation.
I agree with you that the EC cleared him, but I'm saying that even what the EC themselves did, was it lawful? It's another subject that we have to debate. Because an intention to relinquish your citizenship of another country, does it equate to relinquishing? Unless we want to draw an analogy that once I have evinced the intention to actually renounce my citizenship, therefore I have renounced.
Where somebody says, I've applied to renounce, and the other country says, we will not let you renounce.
Do you? I mean, I don't have any such evidence.
Okay.
I don't have any such evidence. But the point I am making is that it is when you receive your certificate of renunciation that you actually present it to show that you are no longer a citizen of that other country.
Right.
You know, because first of all, how am I even convinced that your application you indicated and etc. is in the custody of the appropriate office, as you have claimed? You can only have that if the communication comes that your renunciation has been granted. Here you are.
No, they say there was
so
an
strictly speaking, you made in your preliminary comment, you made a very fantastic point about the strict constructionist application in this particular matter. And you were urging that the courts have at least gone for what they are used to.
I was not urging anything. I was asking questions.
That's why you were urging. But I don't want you to run away from it. You were saying that the courts would have applied the modern purposive approach, in which case they would have been liberal enough to know that once the person evinced the intention to relinquish his citizenship, and then there was acknowledgement and all that. Therefore, and you said they should have drawn some inspiration from Zaneto. Yeah, and all that. But you see, there is precedent also in this particular matter. If you look at clearly, I mean, the conviction of, and there's a slight difference anyway. I am not one of those who buy.
Not slight difference.
Between Adamu Dramani Sakande, there is a difference.
This a man.
I don't want.
This is a man that we are told the evidence showed that he was holding 3 different passports.
That's why I'm saying that.
And whilst in Parliament, he was traveling on them.
Yes.
You can't say the same.
No. Yeah. I am not party to those who say so.
Okay. Yeah.
But the most important thing is that in that case too, he was accused of false declaration. That's one of the charges that he faced, false declaration.
Which was found to be a fact.
It is the form that he actually declared. And the court found to be a fact that at the time he made that declaration, he was actually holding the passport of 2 other countries apart from Ghana. So he was convicted. Now, in this particular case, yes, as you have indicated, there was no, documentary proof that there was an intention or evince an intention to renounce. In J.H. Kwesi's case, there has been. But fundamentally and strictly speaking, even though there was that intent, at the time he filled the form, he did not attach any certificate of renunciation. And he did not have any. Strictly speaking.
There was that a requirement to the form, filling the form?
In the form, you are supposed to declare that you don't owe allegiance to any other country. And we are saying here that once you have signed up, and there is even an oath that you have sworn, and indicated clearly that you don't owe allegiance to any country, and you don't have a certificate of renunciation.
So we are not actually debating the judgment now. We are talking about the prospects.
So I'm just moving to that. So now the point is this: they are assuming a risk. On the night of 6th January, when my learned elder brother, then minority leader, the Honorable Haruna Idrisu, made a very emphatic point that they were going to allow him to sit down and get sworn in, and he was assuming all the risk to himself. Whatever was going to happen, the consequence, he was ready to take it. And then people were talking about the fact that once the process had been brought there to prevent him, he should quit the place. I mean, they insisted. And today, the Apex Court has made a declaration, so he's out of office. Now, they are assuming, as you have rightly pointed out again, they are assuming a particular risk. Because, mind you, if I'm a prosecutor, I will need not more than 2 witnesses to prosecute this matter. And that will not take me 6 months.
But you wouldn't determine how the prosecution
No, I'm saying that I'm not saying that I'm the prosecutor. I am not even in that office yet. Because I don't need more than 2 witnesses to prosecute it. In any case, what would be the essence of going through all this laborious process for them to be a prosecution and then is convicted? Because remember that in the prosecution, he can either be convicted or acquitted and discharged. Nobody can be certain about anything because there are 2 sets of facts. Remember that in civil cases, the proof is just on the balance of probabilities, but in this, it has to be beyond a reasonable doubt. And the prosecution will have to marshal their evidence in such a way that they convince the trial judge that there has been a proof beyond a reasonable doubt. So if they want to assume that risk and say that, yes, again, by our law, once he's on trial and he's not convicted, he's qualified to contest. Until you convict him, you cannot say. So, somebody...
In fact, by the time of the elections in 2020, he was qualified.
Yes.
It is by the time of picking the nomination
that he was not.
That,
yes,
for lack of the certificate of renunciation,
absolutely,
he has suffered.
That is what has actually led to the pronouncement. Right. Interestingly, 3 days ago, a classmate of mine in secondary school called me and said, he wants to come to me to consult me on whether it is possible to take an action to restrain Jechikwesi from contesting the Assin North seat. I told him that I asked him what his basis was. He said, he's anticipating that should he be convicted, it will amount to causing a financial loss to the state. I said, that would be far-fetched analogy. I told him, what is happening is that the prosecution, nobody can sit and judge that the consequence is that he must necessarily be convicted because that will be sub judice. And we leave that to the court and the evidence that will be marshaled and all that. But the point fundamentally is, as he has rightly pointed out, and as all other NDC people I've heard have stated, they are assuming a certain risk. A risk that can pay off or have consequences on them. And that is how life is anyway. You assume any risk, whatever the consequences, you bear it. So in the end, I think that if they exercise caution and decide that on the basis of this, we are not too sure what will be the outcome, so we are bringing a different candidate, it's another issue. But if the party unanimously says that, look, we are bringing the same person, the consequences we are ready to bear, so be it. It will enhance our democratic growth. But remember that we may be back here one day discussing. If he's acquitted and discharged, hooray and hallelujah to all of us. If he's convicted, then we may have another by-election in the same constituency before 2024. That is, if there is conviction before the 2024 election. And I don't think that is what any of us would like to anticipate or even think about or contemplate, because that will amount to excessive waste of our resources as a state in pursuance of this democratic right. So I will say that, yes, let's wait and see. But when you assume a certain risk, you have to bear the consequences of that risk you have assumed, if in the end you are not vindicated.
Right. So there are those who say you have a Herculean task to undo the 3,000 votes that he leads with.
Oh, it's not 3,000, is it? Can you check it? It's not 3,000.
I'm checking. It looks like it is
not 3,000.
Yes, whatever it is, something in that region. How is that feasible for you? as a party?
I have indicated to you that, first of all, the presidential election, we won it in 2020. I've indicated that to you. So what we need to do is to convince our following, strictly, that number that voted His Excellency Nana Addo Dankwa Akufo-Addo. We have to marshal all forces and convince them that the candidate we are bringing is the best person who can bring them development. And remember that, as I said, we've already done a lot of development there, not because of the by-election, but because we need to develop all parts of the country. And then also the by-election will bring in more development. But the dynamics will also change because, remember, that the candidate we presented in 2020 is not contesting in the primary.
Yeah, you have changed the candidates.
Yes, there are two other new people who have come in. And so their personality will also count in this particular election because it will mean that the Honorable Abena Droa, who lost the election to J.C. Question, who is no longer contesting, the new person who is coming may be one who is appealing and acceptable to all the MPP members and even appealing to some NDC members. So the dynamics of 2020 will be completely different from the by-election of 2023 as we speak. So in the end, I think that the party with the best strategy will win. And of course, we in government, we have moved camp to the place already. Our youth have moved there.
Like you have moved the capital to the...
I mean, we've moved the capital to Assin North. And we're very convinced
but
that
people say...
The strategy we have
people say morally, are you happy with your conscience when you do this only because of a by-election? That you neglect people, and when it's by-election, then suddenly the development starts to show up.
No, I have said something, and I'll say it here. I've said it on other platforms. You see, since 1992, whichever government, it appears that when there is a by-election, the development agenda of the area is catapulted to the highest level. Whether it is NDC in power or MPP in power. We shouldn't limit it to the fact that MPP is in power today. It has happened in the past. It is happening now. Right. It is not correct. But also remember that we have a certain resource envelope in the country, which is not enough to do everything everywhere. Right. So when something like this happens, because of the opportunity to go in there and show the people what the party is capable of, you bring in more development. Okay. Even though the people too will look at what you did prior to the by-election. And remember, as I've indicated, we are not just going there to do new things, but other things.
I'm actually trying to have the results of the last election projected for you. Yeah. And without a doubt, he actually made 3,305. 3,305 votes. That's how he was able to do it. We need to take a break now, but is it not too difficult for you?
No, it's not difficult. Actually, we've looked at all the dynamics.
Part of the campaign they've started,
yes,
your opponents have started, is that this is a guy who has denied you representation. I hear the NDC saying the NPP has denied you representation because they are the ones who went and tried to get you, your MP out, the person you voted for out. But the NPP is also arguing that this is a guy who entered the race without qualification and therefore has denied you representation over the period.
No. This is a guy who has been hard done by. This is a Ghanaian who has evinced an intention to be law-abiding, who took all the relevant and necessary steps to comply with the law. But by reason of the fact that the authorities in Canada were not able to give him a certificate of renunciation, he's suffering the consequences. That's just all.
Right.
And the MPP are playing it because they know that he's a very viable candidate. In fact, their attempt to stop him in the first instance was because they knew he could win.
But even your own party members were also against him.
When?
Some of your party members.
It appears it is your party members that began all of this.
The process was started by your own party members.
Which one?
During your primaries.
Your primaries.
That they started to say he's not a citizen.
Absolutely. So it was your own party.
No, primaries people want to take advantage. They want to contest. And so some members
so
said
you give
that.
out weapons.
Give up weapons. Exactly.
So we need to take a break here. Let's see how the things pan out in Assin North.
So that's very close.
This presidential,
that's very close.
1,000 and
so
50
Nana Akufo-Addo has
Yeah.
16,000,
Yeah.
and John Mahama had 15,000. But Jati Kwesing had 17,000,
Yeah.
500 plus, right? As against the MPP's candidate, Abena, who had 14,000.
Even as against the president.
Right. Right. Okay, so we take a break here. When we return, we go into the camp of the NPP proper on the question of a presidential candidate or flag bearer election. Will it go to super delegates? Because Akmanu also Jiman and the other elders are hoping that there will be a consensus candidate. Is that really feasible? And then if there's super delegates, then they would reduce the number of 10 so far to 5. And out of that number, there will be a Congress proper to elect 1. Will it be Baumia or Alan Chermanting? This show is brought to you by the candidate sponsorship of Bank of Africa, strong as a group, close as a partner, MTN everywhere you go. Ashesi University, educating ethical and entrepreneurial leaders for Africa. Robert & Sons Optical Services, your comprehensive eye care service provider for 31 years. My Way Insurance, dial *165# on MTN to join. Duraplus, how you get your water matters. Remember, where Duraplus goes, water flows. And DBS Industries, roofing, Papa Efie. I'm Samson Ladi Anyanini. My guests you have been listening to so far, Joseph Dimdiok Penka, Inusa Fuseni, Martin Pebu, you heard him earlier. Erastus Asaridonko was the first that you heard, and Dr. Tony Edu. We'll be right back.